Welcome to the class of Conveyancing Law in Practice. The unit code is BLW4110. My name is Dennis K. Kiura. We are supposed to go through the topic of the contractual stage of conveyancing. The process of conveyancing involves 4 major steps. It begins with the pre-contract stage, it moves to the contract stage, then it goes to the completion stage, and finally goes to the transfer stage. Now, the process of transferring an interest in land, which is known as conveyancing, involves the preparation of a contract after the conveyancer, who is the advocate, has done what we call the pre-contract stage. The pre-contract stage basically is what students of law should understand as the due diligence stage, or in common language it is known as the searches. What distinguishes contracts for sale of land and many other contracts is because land is a special subject that is also transferred in a very special way. There are stringent conditions that must be complied with when the advocate is preparing the contract for the transfer of land. Importantly, our law requires that for a contract for sale of land to be enforceable, it has to be written. This is what is found in Section 3, Subsection 3 of the Law of Contract Act, Cap 23. And what that therefore means is that for a contract of land to be enforceable in the event of a breach, the same has to be written. But before parties can even enter into the contract itself, the written contract, it is common that terms and conditions have to be negotiated between the parties. And it is only when these terms have been negotiated between the parties and the parties are satisfied with the negotiations and the terms, only then would the contract be reduced into writing. And even before the parties get into the written contract, it is also common that a formal offer is exchanged by the parties. Now, this offer, which forms the foundation of the contract, can also be written subject to the contract. What that means is that the offer does not bind the offerer until the offerer and the offeree have entered into the formal written contract. And the thinking why it has to be subject to contract is because this gives the offerer an opportunity to also undertake certain other investigations before they can formally bind themselves in a written contract. The beauty about conveyancing in our jurisdiction is that we do have what we call the LSK conditions of sale. The LSK conditions of sale give an outline of what a contract for sale of land should capture. But it is important to understand that the conditions of sale, which also contain the agreement of sale layout, are not binding. The conditions are not binding on the parties. In other words, what it means, the conditions of sale as prescribed by the Law Society of Kenya of the LSK conditions of sale of 2015, what they do is that they give a guideline. They are supposed to operate as a guideline. In other words, the parties can reproduce them as they are, or they can alter, they can amend, they can improve. They do not bind the conveyancer, but they are an important guide. And even in the worst of the scenarios, it is possible that the conveyancer can actually just reproduce the LSK conditions of sale as they are. But it is important that we go through the prescribed agreement for sale layout, because this is what forms the generally agreed agreement for sale, to see what the conditions are and what the implications are. Now, even as you engage in the drafting of a contract for sale, the conveyancer must understand what these clauses mean. And some clauses, of course, are in fact more critical than others. It is not unusual in the world of contracts. Now, the simplified format for sale agreement, which we are calling the agreement for sale layout that is contained in the LSK Conditions of Sale of 2015, first of all, there is the clause on commencement. This is a very critical clause because contracts are always time-bound. It must be clear to the parties when this particular contract will begin and when it will end, because time is always of the essence when it comes to contracts. Ordinarily, it will be usual that parties will provide that the contract will commence at the time of execution. This means at the time when the contract is signed. That is the general norm and the general understanding. It is, however, allowed that parties can prescribe a different date of commencement within the contract itself. Again, it is perfectly lawful to have a different commencement date from the date of execution of the contract. Another important clause is the clause on interpretation, also known as the definitions clause. Now, contracts can contain certain terms that could have a different meaning from what is generally known, or that could have a technical meaning within itself. In other words, it is possible that a contract can have words that have a special meaning in the particular contract, away from perhaps the English meaning, away from perhaps what is generally known to be the meaning of those phrases. Now, if that be the scenario, then it's important that you have a clause on interpretations and definitions. It is also important that these clauses that are contained in the definitions clause, whenever these clauses are used in the body of the contract, it is important that such clauses are capitalized. Any person, therefore, reading this agreement or this contract, when they come across these clauses and they're capitalized, then they understand that these clauses have got a special or a technical meaning within the contract itself. Another important clause to have is what we call the recital clause. Now, this is the clause that gives the background of the contract, is the one that gives the history of the contract. This is the clause that explains the position of the parties in the contract. For instance, in a typical conveyancing transaction, these clauses will talk about whereas the vendor is the registered proprietor of the land, etc., whereas the purchaser is interested in purchasing the said property, etc. So basically, the recital clause is the one that describes the background of the transaction. And therefore, someone reading this part, before going further, is able to understand the nature of the transaction and the standing of the parties in the transaction. And therefore, this particular clause ought to be brought out in a very clear way so that a reader of this contract or the consumer, that is the purchaser and the vendor, are able to come out clearly and are able to be seen what their position is in the arrangement. The next clause is what we call the consideration clause. I want to say that this is a very critical clause in the contract for sale of land, and even the bulk of the disputes that arise from the process of conveyancing will typically be founded on the consideration clause. Now, this particular clause is the one that will talk about the price that the parties have negotiated. This is the clause that will talk about the deposits payable. This is the clause that will talk about the installments payable. It's a clause that will talk about the value of each installment. It will talk about the intervals within which these installments should be paid. Every conveyancer must understand that the interest of parties in a conveyancing process are always in conflict. The interest of the vendor is to get the money. The interest of the purchaser is to get the property. But these interests are always in conflict. The vendor always fears that he can part with his property but not get the purchase price. The purchaser always fears that he can always part with his money and not get the property. That being the scenario, therefore, the consideration clause must take into account these competing interests. The drafter, the conveyancer, must think of how to protect the competing interests of these parties. Quite often, what will happen, the advocates involved then come in very strongly to ensure the competing interests of the parties are protected. This is mainly done by ensuring that the advocates act as stakeholders in the process. And this is largely secured by way of advocates exchanging what we call professional undertakings. And I am restating that this should be contained in the consideration clause. Stakeholders means, where advocates act as stakeholders, it means that they will hold the monies that are going to exchange hands without moving this money to any of the parties until the property has successfully moved to the purchaser, and upon confirmation that the property has successfully moved to the purchaser, only then can the money be securely released to the vendor. An advocate must be able to, the advocates involved must be able to agree on the wordings of the professional undertaking, and they must also be able to agree who should give the professional undertaking to who. Depending on the scenario, it is possible that the advocate of the vendor gives the professional undertaking to the advocate of the purchaser. It is also possible that the advocate of the purchaser is the one that gives the professional undertaking to the advocate of the vendor. Another important clause is what we call the completion clause, and this clause largely talks about how the parties will exchange the documents and the installments. It is normal that contracts for sale of land will usually provide for 90 days as the completion period. What that means is that within this period of 90 days, the vendor should ideally have received his money, and the purchaser should have received the title to the property in question. The completion clause and the consideration clause must be drafted very carefully so as to ensure that parties and the transaction in question ends successfully and lawfully. Depending on how the consideration clause has been drafted and how the completion clause has been drafted, then we would then move to what we call the completion stage. But before we move to the completion stage, it is important that we're able to understand what documents would be involved in the process of a conveyancing. These documents are typically what advocates call the completion documents. It will depend on whether it's a freehold or whether it's a leasehold, but largely these completion documents will include things like the original title documents, the consents that would be required, the clearances, the discharge documents, if if the particular property was a subject of charge, the duly executed transfer documents, copies of ID of the parties, the passport photos, the PINs, and spousal consents, and such like. These are the documents that would typically move from the vendor's advocate to the purchaser's advocate. And once these documents have moved from the vendor's advocate to the purchaser's advocate, then it's important that then the transfer stage can be effected after that. It is also important that when you are writing this particular contract, it's important that the conveyancer is able to prescribe any specific and particular matters that could be affecting the property. For instance, it would be important to talk about if there are any rights, covenants, any restrictions that could be a subject of this property. If there are things like charges, these again are matters that could be affecting the property, because parties will have to agree on how these matters will be handled. For instance, if we talk about a property that is a subject of charge, the purchaser must be aware of this, and they must be able to agree on how that aspect of charge will be handled. It might involve that if it is a loan that had a balance, that such a loan has to be cleared. It will be important that you agree on whatever other matters that are affecting the property, how the same will be handled, and how the purchaser will take over some of those aspects. More often than not, the property will usually be sold free of charge. In other words, it will not be a subject of any encumbrance, more often than not. But it is also possible that such a property is also a subject of charge. And yes, a conveyancing process can be done successfully even when the property is a subject of charge, provided that the parties have disclosed and provided the parties have been able to agree on how that aspect of charge will be taken care of. Of course, it is also important to understand that if a property is a subject of charge, it means that the chargee, that is the bank, will have to be involved. And the bank will have to consent to this particular process. The bank will have to sign certain documents like the discharge of charge. And therefore, as long as the parties are in the know, the purchaser is aware, and the parties have agreed, and they have done proper communications to the bank, then such a process can be done successfully. Now, the other important clause that will be contained in such an agreement is what we call the possession clause. Typically, possession will not be granted to the purchaser until the process has been completed. But then again, within the domain of freedom of contract, it is possible that parties can agree differently. In other words, it will not be illegal even if possession is given to the purchaser before the completion, but the more advisable requirement would be that such possession should be granted after completion. Of course, the risk in giving the purchaser possession before completion is obvious, given that it is possible that the transaction may not necessarily go into full completion. Certain breaches could arise. And if breaches arise, and at that particular point in time you had given possession to the purchaser, it could present certain other challenges. And therefore, I would say that whereas it is not unlawful to give to give possession before completion, it is advisable that possession is given after the completion. Another important clause that ought to be captured in a contract of conveyancing is what we call the penalties or the remedies for breach clause. This is the clause that will set out the consequences for breach on the part of either party. A breach can arise from the purchaser, a breach can arise from the seller. This clause must prescribe if the breach is by the seller, what happens? If the breach is by the buyer, what happens? The conditions of sale generally prescribe that in the event of a breach by the seller, the purchaser would be entitled to a refund of the monies that will have been paid at that point in time without any deduction. But in the event that the breach is by the seller, in the event that the breach is by the buyer, the conditions of sale prescribe that the seller will be entitled to deduct an equivalent of 10% of the purchase price as the liquidated damage. Like I explained earlier, that is what the LSK conditions prescribe. It is possible that the parties can negotiate differently. It is not unusual, for instance, for parties to agree that even in the event of breach by the seller shall refund the monies with a certain interest as a way of compensating the buyer for the breach by the seller. The next clause that is very important in a conveyancing contract is the clause where the conveyancer should incorporate the law society conditions of sale. This is very important. We said that the conditions of sale do not bind the advocates in the contract. But the importance of incorporating the LSK conditions of sale is that in the event of an omission in the contract, for one reason or the other, in the event of any omission, what will happen is that the LSK conditions will step in to bridge that gap. What do we mean? What we mean is that the LSK conditions are normally incorporated, subject to them having not been altered or amended in any way. So once you have got this clause in your contract, it means that the LSK conditions are automatically incorporated in your contract. The security in that is that in the event of any omission, for one reason or the other, the LSK conditions of sale will step in and they will be given the proper meaning and interpretation to resolve the dispute that could arise as a result even of that omission or as a result of the breach of the contract itself. Another important clause that every contract for sale of land should incorporate is the clause on costs. And as the advocates incorporate this clause, they need to understand what the law says in terms of costs, in terms of who bears what costs. The law of conveyancing typically is very clear on what costs should be borne by which party. It is normal, for instance, that the contract will provide that each of the parties will bear the cost of their advocates. That is very normal. It is possible, occasionally, that one party can bear the cost of both advocates. Again, it will not be illegal, as long as it has been agreed between the parties and it is properly documented. But there are typical costs that must be borne differently by the parties. For instance, it is normal that the purchaser will typically bear, of course, will pay the purchase price. The purchaser will also pay the stamp duty. It is also normal that the purchaser will pay the transfer costs. These are normally paid to the land registry. The stamp duty is a tax that is paid to the Kenya Revenue Authority. The seller or the vendor, on the other hand, will typically bear the cost of producing or obtaining the completion documents. Some of these completion documents will obviously come at a cost. For example, when you talk about the consent of the Land Control Board, there are certain monies that have to be paid. If you talk about the consent of the National Land Commission, there are certain costs that have to be paid. And therefore, these costs, the seller will bear the costs of the completion documents and also the capital gains tax. It's also normal to have miscellaneous clauses in the contract. These are what you normally call the general clauses that will typically talk about things like the applicable law, the force majeure clause, and the likes. It's also important to have a notices clause that will normally stipulate the manner in which any notices between the parties should be transmitted in terms of addresses, the places, and even the manner. For instance, you could agree on submission of notices by physically, by emails, and etc. Jurisdiction clause, it's important to also have a clause stipulating the law that will be applicable and the courts that will have jurisdiction. Also have a testimonium clause. This is the one that connects the body of the agreement to the part where the parties will now execute the agreement. The execution clause, this is a clause where the parties basically are going to sign, basically to confirm that they are in agreement with whatever it is that has been put down in the contract. You're also going to have an attestation or verification clause. This is a clause where the advocates of the parties ought to witness or to attest to the contract itself. In conclusion, what is important is that the conveyancing advocate must properly advise the parties for purposes of negotiation. The conveyancing advocate must understand the importance of having a properly drafted agreement. And if an agreement is properly drafted, even in the event of a dispute, such a contract will be a lot more easier to enforce, it will be a lot more easier to interpret, and even if it finds its way to the courtroom, it will be much, much easier for the courts to adjudicate on a properly drafted agreement. Thank you very much.
These televised lectures supplement our robust online learning going on our MKU online platform. You can view more on our televised lectures via our online platform. We are in a digital era, and Mount Kenya University knows this. The following are the steps to follow so as to complete your online application. Download the application form from the website www.mku.ac.ke. Attach copies of your academic certificates and ID. Pay the application fees via M-Pesa pay bill number 270988. Your ID is the account number. 2,000 shillings is the charge for a postgraduate. You can also deposit in the bank accounts provided on the website. Then email all the above to apply@mku.ac.ke.